you wouldn't store a lot of letters. You'd throw away ones that didn't mean too much, and maybe you'd have a few that you kept. Email can live forever.
What is digital estate planning?
Digital estate planning is the process of discovering and writing down your digital assets, what online accounts you have, and then deciding what you'd like to do with those when the inevitable happens. Either you pass away or you become incapacitated. A lot of your assets likely exist in the cloud.
What are the legal formalities when accessing data after death?
Accessing someone's accounts after they've passed away is really governed by both federal law and state law. And recently, within the last year, 29 states have adopted digital asset laws that really provide the guidelines to how a fiduciary is able to manage your online accounts. About anything that's on your personal property, such as a computer or a tablet or a smartphone, those assets are controlled by existing estate planning laws and probate code. Where the complication develops is when we're talking about assets that are in the cloud, sitting on a third party's equipment and governed by a terms of service agreement.
Who can have access to data if not specified in the will?
The default for access by the fiduciary is different depending upon which class it is. There was a lot of battling, lobbying, and eventually it came down to dividing the digital assets into two classes. Electronic communications, which would include your email, your social media accounts. The other class is everything else. Documents, it includes photos, it includes videos, loyalty reward. If it's electronic communications, the default is the fiduciary does not have access to that without your written authorization. And with your other digital assets, the second class, the default is they get access to it unless you prohibit them from accessing it.
What are some of the privacy concerns associated with accessing accounts?
Clearly there are privacy issues, and this is one of the reasons that there was a lot of lobbying. The ACLU was very strongly involved in trying to protect the privacies of the decedent as well as the third party. So for email, every email has both a sender and a receiver. May contain private comments, statements, thoughts from a third party, the person that sent or responded to your email, and they're not going to be consulted whether or not they want those emails released. People mistakenly think somehow that their email is very private when in reality it is sitting on another company's equipment.
What do you foresee is the future of digital estate planning?
I think we're still lagging behind. How will these laws actually be interpreted in each state? So few people have really had to fall back on these laws in terms of disputes within the estate. I mean, everybody is looking to see how the courts interpret these digital asset laws when there are challenges. What happens when beneficiaries don't agree with perhaps what the account owner wanted? Maybe you want those photos deleted, and maybe beneficiaries and heirs don't want them deleted. What happens then? Right now we're really at the first baby step with digital estate planning, and it's going to be interesting seeing what develops from here.